We're with Adam Feldman. Adam is a criminal defense attorney in Phoenix, Arizona. He's agreed to answer some online questions related to assault. With that said, let's go into the first question, Adam. This is specific to you, actually. What is your fee for defending an assault case?
It's a tough question to answer. I would need more specifics. The reason is this: assault can be a misdemeanor assault in the city court. It can be a series of misdemeanors, maybe a bar brawl, also in a city court or a justice court, but it can go up to a Class 2 dangerous felony in the Superior Court. So it's tough for me to answer that question. Maybe let's start with misdemeanors. It's still a little fact specific. I've taken, the range, I guess I would say, is anywhere between $2,500 to $5,000 for the misdemeanor cases, but it just depends on the details of the case and which court we're in, things like that. When it goes to the felony, really tough to say. I've done them for as little as $5,000. I've done them for as much as $50,000. It really just depends on the details, the nature of the case. Are we going to need experts? If so, how many? There's just so much to it. So tough to answer without any additional information, but you always have the ability to more specific questions or call the number as well.
Okay, all right. Next question we have, and this one's more specific. I've been charged with 2 counts of assault with a deadly weapon, but it wasn't a gun or a knife. It was a piece of wood in a bar fight. I was outnumbered, and yet I'm being charged. Why aren't they being charged?
It's a great question, and I have no good answer as far as why aren't they being charged. I see it all the time where the initial aggressors, the instigators, the people who started everything, they're sitting pretty, they're not in jail, they haven't been charged with anything, when this is truly a product of their doing, and you're the one who's facing these horrible charges. Why do they charge you? There's no good answer other than maybe they called 911 first, or maybe, a lot of times we see it where the bouncers are the aggressors, and the cops have this familiarity with the bouncers, so they're going to take their side versus you. But the charges are super serious. It's a Class 3 dangerous felony, which means, and I'm not telling you you're going to prison, but ultimately, if you went to trial on a Class 3 dangerous felony, which is aggravated assault with a dangerous weapon, and you're convicted, you're looking at 5 to 15 years in prison, mandatory, and that's even if you have nothing on your record. So really serious, but what you're describing to me is one of the best defenses for somebody with aggravated assault. Self-defense or defense of another, any of those two, or defense, it's basically called crime prevention defense, which is stopping somebody from committing an assault on you, similar to self-defense. Those are huge defenses for a jury. When you're trying to come up with something very lawyerly, juries often, they glaze over and they don't really understand it. But when you're talking about self-defense, juries see this on TV, they know it from day to day. They get it, and it's a phenomenal defense to use when I'm defending one of my clients.
Okay. Next question was, my son is facing a charge for assaulting an officer in jail. Is there anything you can do for him?
Always. One of the things that we find when I'm defending a client who's in jail is there's usually a ton of video surveillance going around. And if you get in early enough, we can secure the video footage, and that can make or break the case. A lot of times the client will be saying, hey, I was defending myself, or I didn't do anything wrong, and we see the video footage and it shows otherwise. But even in that case, we can still help you, because ultimately you're in jail, meaning something already happened, and now you've got a new charge, so the stakes are even higher. So yes, we can still help you out even if you're in the wrong. But a lot of times what we see is that these detention officers are very quick to lie about what happened, and the next thing you know, you're charged. But when we get the video, we can see, well, things aren't exactly the way that the officer said, and it's more consistent with what the client says. And in those situations, we can do an amazing job defending not only the criminal case, but pointing you in the right direction for possibly going after the county, after the officer, after the city civilly, and getting money for these false allegations against the defendant.
Okay, wow. Next question here is if you successfully defend my assault case, will I still be, well, this ties into that, will I still be facing a civil case?
The answer is it's possible. So you can win a criminal defense case, meaning they charged you, you won because of self-defense, or you won because they didn't have enough evidence. Whatever the reason is, you won your criminal case. Can the family or the person or whoever the alleged victim is still come after you civilly? Absolutely. I mean, the most notorious example of that was O.J. Simpson. If you remember, I mean, he was found not guilty at trial, but then they went after him civilly even after he was found not guilty. And then they ended up doing civilly, he was found responsible, had to pay out on that. So can they come after you civilly? It's possible. Are they going to? Well, it depends. Because whenever an attorney takes on a case to go after somebody civilly, the biggest question for that attorney is, where's the money? Yeah. Am I going after a student at Arizona State University who probably doesn't have a dollar to his name? No, most lawyers aren't going to take on that case. But maybe if you are the bouncer at a nightclub or something, and you're the defendant there, well, then they could sue you as well as the nightclub. So, if you are maybe employed or working for your employer at the time of the assault, maybe there's a better chance that they are going to come after you civilly, even after you're found not guilty.
All right. Next one is I have a court-appointed attorney for an assault charge. My family has all pitched in some money, and I'm looking for an attorney. How would that work? Meaning, if I find an attorney, will they meet with a court-appointed attorney to transfer my case?
You got it right. That's basically what happens. No matter where you are in the case, you can almost always hire another attorney. The exception is if you're a couple days out from trial, odds are that a judge is not going to let you switch attorneys. But if you're early enough in the proceedings, and that's the majority of cases when people come to me, they have a public defender or they have an appointed attorney, and they say, look, we got together enough money, we want to hire an attorney, and it's real easy. What I do is I file a substitution of counsel. I get the old attorney to sign off on it. We submit the motion substituting me in for your appointed attorney, and the courts almost automatically grant that. Then I get the entire file from your old attorney. So that's police reports, emails, anything he or she did on the case, it all comes to me, and it comes to me pretty quickly. So 95% of the time, it's a very easy transition where we can get it taken care of immediately.
Excellent. Okay, well, that was the final question. If you have any additional questions for Adam, you can just post them in the comments section below. He's agreed to get back to you. Obviously, you can reach out to him directly. With that said, Adam, thanks for your time.
Thanks, Ryan. And like a lot of these questions that we see, they often tend to be pretty general in nature, but if you have any specific questions, and usually when you're talking about somebody's case, they are going to be specific, easiest thing to do is call me, 602-540-7887. Consultation's free. I'm more than happy to answer any of your questions for free, and we'll go from there. So thanks again, Ryan, and we'll be in touch.
Thanks.